Hello, this is John Milburn for Laws 11059 Statutory Interpretation, and this is the formal lecture for Week 9 dealing with traditional common law approaches, and this is for Term 3, 2018. As I had indicated, there's no live session this week, which would be Wednesday the 16th of January. So this is the lecture in lieu of that live session. I had indicated earlier that I would deal with the issue of last year's examination question. I've decided to defer that to week 10. Part of my commitment to you in week 10 is to provide you with examination advice. So logically, dealing with how we invited you to answer the question last year would be appropriate for week 10 rather than week 9. But week 9 is also significant in that it provides you with an opportunity to provide some feedback. So I like to think of week 9 generally as feedback week. In other words, it's your opportunity to discuss any problems that you might encounter during your response to assessment work. If you have any issues of concern that you'd like to discuss, please raise those through Q&A or save the questions and we'll deal with them in the live session next week. As you might expect, I'm very keen to receive feedback about this unit, about the assessments that you have completed or been asked to complete, and very importantly, I'm keen to discuss any further assessment requirements that you have in advance. So feedback week is a two-way street in that regard. I'm keen for you to let me know what you think about the unit, and you can do that anonymously by hitting the big red button at the top left-hand corner of Moodle, which is Have Your Say. In the course of providing feedback, you can provide me with specific information. Do you believe that you're gaining the knowledge and skills that you'd hoped to obtain in this unit? And if not, why not? And what do you think is missing? And I'll try and fill in any gaps. So I do note that we have good levels of participation by people in this unit in the live sessions, but there are many, of course, that have not joined us for the live sessions and perhaps have not engaged in the Q&A process to the extent that I'd like. So if you're not involved because you've got concerns, please let us know and we'll try to deal with that. So please have your say. It's important for the university. It's certainly important for me. This week, the unit deals with the issue of traditional common law approaches. Most statutory interpretation textbooks deal with this topic in Chapter 1 or maybe Chapter 2. I like the way that Sanson deals with it at the end. Part of the reason for that is that in dealing with the traditional common law approaches at the start, it tends to become ingrained in your mind disproportionately to the point where we teach all the common law principles, we go through it in depth, and then we say, but bear in mind, of course, that these days we look at the statute first, and then we apply the common law principles around the statutory provisions. To my mind, as I've done in this unit or attempted to do in this unit, teaching the statutory interpretation principles based on statutory provisions first and then dealing with the common law and finally the common law presumptions, I think is the logical and appropriate way to teach the unit. So this week we're dealing with those common law presumptions. So in some ways we're going back in time, and the intention is to show how, from a modern statutory interpretation perspective, we deal with those common law presumptions in and around the statutes and the case law. Okay, sound a bit overwhelming? Let's see if we can provide some meat on the bone, as it were. Before I start to talk specifically about the common law presumptions, and I'm assuming that you've read Chapter 9 of the text anyway before you look at this session, so you'll know what I'm really talking about, I'm going to introduce you in some degree of depth to a resource online, free, highly authoritative and excellent in terms of explaining not only statutory interpretation, but also the process by which legislation comes into existence. Now, you might say, well, what's that got to do with common law presumptions? Well, the answer is that the website that I'm going to introduce you to, which is the Queensland Legislation Handbook, many of you may know of that already, but if not, it needs to become your new best friend, as it were, deals with the issue of these common law presumptions in the context of how laws are made and in the context of the Acts Interpretation Act and other foundation, if you like, pieces of legislation dealing with statutory interpretation. So my attempt now in explaining the common law principles is to very much supplement, initially at least, rather than replace what Sanson has said in her excellent textbook. So let's have a look at the Queensland Legislation Handbook. If you are aware of this resource already, I'd ask that you please bring that up on your screen. If not, you may need to pause this recording and find it. Hint, you'll find it through the Queensland Government website, Department of Premier and Cabinet, and it's part of the policies and codes governing Queensland government handbooks, and you should find the Legislation Handbook, also known as the Queensland Legislation Handbook. Try and find that now, pause the recording, and come back to us. While you're doing that, I'm going to share the screen and show you the website for the Queensland Legislation Handbook. So that hopefully is now the website that you see on your screen. So the Legislation Handbook is part of the Queensland suite of handbooks. So there are a number of them, and I'd urge you to look at the entire suite. But tonight we'll be concentrating on the Queensland Legislation Handbook. I should indicate that these handbooks are quite different to another resource that I refer to regularly, and that is the bench books. So the bench books are really from the perspective of the judiciary, so you'll find them through courts. Tonight we're dealing with the Legislation Handbook, which deals with the Department of Premier Cabinet. So we're really looking at it from the legislative branch of government rather than the judicial branch of government, which is the bench books. Okay, and you'll see in the heading, the introduction to the Queensland Legislation Handbook, that the legislative process in Queensland is managed by the Office of the Queensland Parliamentary Council. So it's the Queensland Parliamentary Council Office that deals with the issue of drafting legislation, Acts of Parliament, and subordinate legislation. Subordinate legislation, primarily regulation, rules, ordinances, things of that nature. So this is all done through the OQPC. And the handbook is used for that body in terms of deciding upon policy or instructing officers how to help them to work effectively with the Office of the Queensland Parliamentary Council. So the intention is for this handbook to be used by practitioners in the executive who are working with the Office of the Queensland Parliamentary Council with a view to making laws happen, for want of a better term. It is an excellent publicly available resource, and it goes to show the workings behind the curtain, so to speak, so there's a lot of transparency here, in the same way that the bench books provide a degree of transparency as far as the way in which the judiciary goes about its directions to juries in criminal law trials primarily. So the introduction gives you an idea of what the Legislation Handbook is all about. Now you'll see that this handbook can be downloaded, and you'll see a PDF download function at the top right-hand corner. So the Queensland, also the Office of the Queensland Parliamentary Council is responsible for drafting government bills and most subordinate legislation in Queensland. So it's got a huge task, and it's governed, initially at least, by the legislation handbook. But as I said, please do look for the other alternatives that are available. My apologies. I'll just end that call, and I'll phone them back. So, and I'll just turn the recording down. Okay, again, my apologies. So what we have here is the table of contents that deals with a number of issues in relation to the drafting of government bills and subordinate legislation in Queensland. The first thing to note is that the table of contents is extensive. I'd urge you to look generally at the table of contents, and what you're doing there is no different to what you do in considering any piece of legislation, where you look at the headings, get a feel for the document, and you'll see that the document, of course, is reproduced electronically as well as in paper form. I'm going to highlight some particular things that might be of interest to you. Let's start, illogically as it were, by looking at the middle of the document and getting a feel for some common law presumptions as they apply to, say, subordinate legislation. Subordinate legislation is topic number 6.0, and you'll see specifically topic 6.5 that deals with general presumptions that legislation will be prospective. Click on that link or look at it through the website for the PDF, and you'll see here that subordinate legislation commences on notification of the legislation website or on commencement of its authorising act. There is a general presumption that legislation, whether an act or subordinate legislation, will operate prospectively. Generally, courts will override the presumption only if the empowering act contains a provision authorising retrospective operation. The one exception is where the subordinate legislation expressly provides for the retrospective operation of a beneficial provision. So you'll see there that intertwined in the commentary is in fact one of the common law presumptions that you would have read about in Chapter 9 of your text, and that is the presumption that legislation acts prospectively rather than retrospectively. And it provides some practical information about how courts will override the presumption only if the empowering act makes it very clear that it is intended by Parliament to have retrospective operation. In other words, if it is intended by Parliament that in creating the legislation, in this instance, it overrides the traditional common law approach. If we look at section 6.6, it deals with the retrospective operation of a beneficial provision. In other words, here we have an exception to the general presumption that legislation will be prospective. Again, we're dealing with common law presumptions. And the retrospective operation of a beneficial provision is expressly permitted under the Statutory Instruments Act, Section 34. Section 34 defines a beneficial provision to mean a provision that does not operate to the disadvantage of a person by decreasing the person's rights or imposing liabilities on the person. And again, Section 34 of the Statutory Instruments Act is a reflection of a common law approach or common law presumption. You'll see then by that common law presumptions or approaches are now often incorporated into legislation. And in this instance, you need to be aware of the Statutory Instruments Act, which is an overriding piece of legislation that deals with the way in which statutory instruments are created. Statutory instruments, of course, include pieces of legislation. I'm going to digress now and just refer to something that I'm sure you're aware of from early in Introduction to Law. And that is the distinction between that which is Commonwealth and that which is state. So under the Australian Constitution, only the Commonwealth Parliament may make laws about a particular list of matters referred to in the Constitution where the Commonwealth has exclusive power. Also, there is a list of matters in the Constitution where the Commonwealth and the states share powers. So have a look at Section 51, primarily in that regard. Which then leads us to this issue of what if the Commonwealth Parliament makes a law which is to some degree conflicting with state laws on the same matter. Again, we refer back to the Constitution, and you'll be aware from your studies that in those circumstances where Commonwealth law is in conflict with state law, it overrides the state law to the extent of the inconsistency, and therefore to the extent of that inconsistency, the state law is invalid. That's really just a segue to looking at another part of the legislation handbook that deals with the issue of liability of directors or executive officers of a corporation. Corporations law is dealt with through the Commonwealth, where it has power to deal with issues to do with such things. So when you're looking at the legislation handbook, when you're considering common law approaches and presumptions, then you need to consider this interplay between the Commonwealth and the state and be aware of the general obligation to look at that which is Commonwealth as dominant over that which is state. So let's look at a specific example, and this example also deals with, it amplifies traditional common law approaches as modified through statute. Section 2.11, 2.11. This is dealing with under the general heading of policy development of a government bill, and it is the specific heading, other matters needing consideration for thorough policy development. If we look at section 2.11.16 or 2.11.16, you'll see that it deals with the issue of liability of directors or executive officers of a corporation for the corporation's offences. In other words, we're dealing with situations where the company has committed an offence, and the question then is whether the directors or executive officers may be held to be personally liable for the offences committed by the corporation. Now, the traditional common law approach is that they would not be, and the handbook makes it clear that proposed legislation should not make those individuals personally liable unless there is clear justification for doing so. In other words, we're taking the common law approach and we're looking at how legislation modifies potentially that common law approach. So in this instance, when dealing with the liability of directors or executive officers, if it's proposed to include a legislative provision imposing this liability, the Premier must first be consulted. It needs to be considered by Cabinet. And if the provision is included, it must not reverse the onus of proof. That is, it must not require a director or executive officer to prove that they did not authorise or permit the conduct of the corporation that constituted the corporation's offence. And these directors' liability principles were published by the Council of Australian Governments, COAG, and that should be considered in deciding whether the imposition of liability in that regard, which is referred to as derivative liability, is justifiable in particular circumstances. So that's in 2.11.16. Now, the reason I'm highlighting this is it's a very good example, I think, of how the traditional common law approach is considered by Parliament, and the process in that regard is quite extensive. It also involves the state having to be acutely aware of the Commonwealth's ability to make laws in relation to corporations and corporate offences. So in doing so, the state must also not only consider the general common law approach, but also consider the Commonwealth approach. Let's look at some other examples of how the Legislation Handbook can assist you in terms of statutory interpretation and understanding this interplay between common law approaches and the statutes that are built around or supplement those common law approaches. You need to understand the drafting process for legislation or subordinate legislation. So have a look at 3.0 that deals with the drafting process particularly. The chapter involves and considers the drafting process from the perspective of the Office of the Queensland Parliamentary Counsel. Now, the office may be involved in the drafting process, and it may be involved in preparing documentation for Cabinet approval. Have a look, for example, at the role of the drafter, 3.5. You'll see there some commentary that relates to the obligation for drafters to legislate using plain English. That is described as the deliberate use of simplicity to achieve clear, effective communication. Lovely wording. And it is now statutory, it is now the best technique for effective communication in legislation, as it is generally in law as we know now. Have a look at 3.5.2, which refers to acts of general application. And you'll see there the suite of 3 pieces of interpretation legislation that you must be aware of. The main one, from your perspective, has been Acts Interpretation Act 1954 from a Queensland perspective. But I now invite you to add to that the Statutory Instruments Act 1992. We've already referred to that in this session. And in addition to that, the Legislative Standards Act of 1992. So all 3 pieces of legislation have a bearing on the way in which statutes are created. Go beyond that and look at some other sections of 3.0. In particular, something that might stand out to you, that may not immediately stand out to you, but which is very important, is 3.7, which deals with other relevant matters. And 3.7.2 deals with explanatory notes and provides some background and assistance in terms of preparing explanatory notes to ensure that they fit within certain guidelines and within statutory process. When we talk about statutory or explanatory notes, we often will also talk about second reading speeches. And the Legislation Handbook deals with that issue as well. So in that regard, have a look at 4.8, which deals with the issue of second reading speeches within the context of the parliamentary process. And if we look at the commentary on second reading speeches as contained within section 4.8, you'll see that it provides some detail, some background as to exactly the process involved around the requirements for the second reading speech and the related procedures. Now, these are set out in documents called the Standing Rules and Orders of the Legislative Assembly. It also refers to the Queensland Parliamentary Procedures Handbook, which is another of these handbooks that supplement the Legislation Handbook. And it goes to describe what is meant by the second reading speech and the debate. And you'll see 5 paragraphs down. Debate on the second reading is a free-ranging debate and may address the principles of the bill, the Portfolio Committee's examination and report, and any amendments recommended by the committee. Now, the reason I highlight that is that when we talk about second reading speeches, the debate itself is an important extrinsic material. But you'll see here that before we get to the debate, there are other extrinsic materials that you may not have been aware of that are nevertheless potentially very important. And that is the Portfolio Committee's examination and report and amendment recommendations by the committee. Now, very often these things are also publicly available and might be considered by you when interpreting legislation. Let's go back and look at some other things in the legislation handbook that might generally be of assistance to you. There's some commentary there at 5.0 in relation to the process of royal assent. And you'll see the commentary there which provides some specific detail. And you'll see that the Clerk of Parliament has the responsibility for the process by which a bill passes the Legislative Assembly and obtains royal assent, and the process by which the Clerk of the Parliament advises the Office of the Queensland Parliamentary Council about details of the assent, and you'll see the process there explained. Also in the legislation handbook, 6.1, that deals with the issue of subordinate legislation and provides an explanation as to what is subordinate legislation. 6.2, how we go about drafting subordinate legislation. So when we talk about subordinate legislation, we refer generally to legislative instruments that are made by an entity under a power delegated by the entity to the entity by Parliament. It also provides some commentary as to why we have these things: to save pressure on parliamentary time, to deal with situations where the legislation is too technical or detailed, to deal with rapidly changing or uncertain situations, or to allow for swift action in the case of an emergency. Also in that area of subordinate legislation, we have the concept, we have reference to a common law principle or common law approach, and that is to do with the concept of ultra vires, which deals with unauthorized sub delegation. In other words, when you're acting as a lawyer seeking to attack a decision that was made, one of the first things that you might consider is whether the decision maker purporting to make this lawful decision in fact had the lawful authority to make the decision. It may be that the decision was based on power purportedly given to that decision maker as a result of sub-delegation of power, and that may have been unauthorised. Now, this is an area that we deal with in administrative law. Subordinate legislation that includes a sub-delegation would be invalid if the Empowering Act does not authorise the sub-delegation to include that sub-delegation. Now, these are, if you like, common law approaches that have been incorporated into the legislation handbook and our law. So even though you don't necessarily see this as something that's based on the common law approaches, it is nevertheless something that springs from that. Let's go back to the legislation handbook, subordinate legislation, and you'll see again some familiar commentary on 6.1, Explanatory Notes. It refers to the Legislative Standards Act, Section 22, another of the suite of 3 pieces of legislation that you need to now be aware of, because Section 22 provides for an explanatory note prepared by an administrating department to accompany all subordinate legislation. It also refers to Section 24 as to what are the matters that need to be addressed in the explanatory note. If we go back to Section 6.13, you'll see there's reference to tabling and disallowance. Now, Section 49 of the Statutory Instruments Act provides that subordinate legislation must be tabled within a certain time, it's 14 days, and it ceases to be effective if not tabled within that period. So there's some technical things there that need to be considered, and these are all avenues for you as lawyers to consider whether legislation is lawful and decisions around it have been lawfully made. Have a look at section 7.0 that deals with the issue generally of fundamental legislative provisions. And that's an important provision in terms of, some important commentary there in terms of some of the traditional common law approaches. For example, the rights and liberties of individuals is an important thing for you to consider. It springs from the common law, but it's now incorporated into this material. So I'd start the reading around that section at 7.11 that deals with what are the fundamental legislative principles. This really is a reference to the rule of law, and it includes reference to the Legislative Standards Act. Look at section 7.13 that deals with modifying or abrogating fundamental legislative principles, the principle of legality. Again, we're dealing with some common law principles here, or common law approaches, which have now been incorporated into this process. And there's some useful things to consider in 7.13, because what we're really saying here is if you have a fundamental legislative principles or a rule of law, for want of a better term, which derive from common law rights, then these are to be protected. So, third paragraph down, the type of common law rights, freedoms, privileges and immunities that are protected by the rule include the following. For example, freedom of movement, freedom of speech, legal professional privilege, access to courts, procedural fairness. These are all part of our rules of law. And you'll see there a reference to an important decision of X7 against Australian Crime Commission, 2013, High Court of Australia 29, in which case a majority in the High Court recognised that the rule was most frequently applied to legislation that affects rights. So the list there is not exhaustive. The X7 case is generally important, and it deals with the general system of our law. All of these spring from the common law. Okay, you've been very patient, but there is one other thing that I just want to show you before I leave the commentary in relation to the legislation handbook, and that is the appendix. If we go down to the appendix, you'll see it includes the legislative process flowchart. This is a really handy, ready reckoner in terms of guiding you through the process of policy through to draft bill, bill for an act, through to the royal assent and the creation of the legislation. That then becomes law, and that is modified by the common law, even though the policy, as we've identified, may have reflected to some degree some of the original traditional common law approaches. I'll now stop the share. So, legislation handbook and the suite from which it is drawn, valuable resource, one that you should keep in mind and refer to. It's publicly available, of course, and you should consider it. Now, as I mentioned earlier this evening, I expect that you would have already read Chapter 9 of your text. If you haven't, please do so now. Chapter 9 deals with the main aspects of some of the important common law approaches, which are the literal rule, the golden rule, and the mischief rule. It also provides some commentary in relation to Latin maxims, and it's closely aligned with what we'll be dealing with next week, which are the statutory presumptions. So there's a couple of questions that you need to ask yourself as you read the material. How do the common law and statutes relate to each other? We've already dealt with that to some degree by practical reference to the legislation handbook. And another question is, do we have a coherent body of law that represents this fusion of common law and statute? So the common law approaches to statutory interpretation do continue to have some use in terms of interpreting legislation, and in that regard, be aware that courts will consider the common law approaches when determining what Parliament meant when creating legislation. And we've already seen that through reference to the legislation handbook. Remember, of course, that the doctrine of parliamentary sovereignty means that the statutes will prevail over the common law, subject, of course, to any contrary statement by the High Court dealing with constitutional validity of legislation. In your case book, there's reference now to the decision of Brennan against Comcare. It's a federal court decision. It's from 1994, and it includes a statement by Justice Gummow, who said, applying the rules of statutory interpretation is different from applying the doctrine of precedent. It would only apply if dealing with the same act and are directly aligned factual circumstances, and that's very unlikely. There's reference to Yeager against the Crown, 1977, where at 45, Justice Mason confirmed that the construction of statutes is a question of law. Therefore, where issues of statutory interpretation arise in the context of a jury trial, it is for the judge to decide what connotation a word should be given, because judges, of course, make rulings in relation to the law as opposed to the facts. Now, when you're reading the material, I'm just going to highlight a few things in Chapter 9 that are particularly important. Have a look at figure 9.1 on page 202 of your text. Now, what this does is it deals with the interaction between the common law and statute in the development of law. The bottom part in figure 9.1 is the past, and the top part is the present. So, for example, you can see there's scenarios A, B, C, D, E, and F. So where an area of law developed over time at common law, but there's now a statute on the topic, that statute may build on the common law through codifying it or extending its operation in some way, or it may replace the common law. This has consequences for statutory interpretation because it affects the degree to which the prior common law may be useful in interpreting the legislation. So I hope that makes sense. The common law has a place to play in all scenarios except the second scenario. You see the cross is, the common law is crossed out. Sometimes new laws create statutory rights that did not previously exist. However, usually they also include material that is subject of the common law. As you read on, you'll see that legal reasoning is considered in scenarios D, which is on page 204, and E, which is page 205, and F, which is page 206. Now, because so much of this relates to this concept of legal reasoning, I have prepared and uploaded for you a separate Zoom session that deals with legal reasoning. It's more in the context of preparing a case note or answering a legal question based on legal reasoning, but you'll see that legal reasoning applies to these scenarios that are referred to in your textbook as well. Now, scenario D is interesting, and scenario D deals with the issue where The common law is developed through reasoning by analogy to statutory principles. Have a look at the case of R against L, 1991, 175, 379. In defence to a charge of rape, a husband said it was a common law obligation for his wife to have sexual intercourse with him. He referred to section 114, subsection 2 of the Family Law Act 1975, which is of course Commonwealth legislation, which provided that a court may make an order relieving a party to a marriage from any obligation to perform marital services or render conjugal rights. Seems an antiquated law. He therefore argued that it was inherent in the Commonwealth legislation that a spouse has an obligation to perform marital duties, render conjugal rights, and pursuant to section 109 of the Constitution, Commonwealth law should prevail to the extent of any inconsistency. The court worked its way around this inventive argument to come to a conclusion that is obviously appropriate and against the argument that were made, but the arguments had some force, so the court had to work pretty hard to get round it. So as the author Sanson mentions on page 205, an ongoing challenge with the analogy's use of statute is the development of the common law, and whilst this is said to be a single law, there are different laws that can affect the way in which something is considered. Now take, for example, Baker against the Crown. That's 2012 HCR 27, where all High Court judges refused to use the Uniform Evidence Act to adapt the common law of evidence in circumstances where Queensland, South Australia and Western Australia have not adopted the Evidence Act. Just a little plug, I do take evidence law, evidence in proof, or at least most of the time. It's a third year subject, and we deal with that clash between the evidence law applicable in the Commonwealth and some states against the Evidence Act that applies in Queensland, South Australia and Western Australia. So scenario D deals with an example of a court referring to common law legislation in coming to its decision. So as I mentioned at the start, when we talk about traditional statutory interpretation approaches, we usually talk about the literal rule, the golden rule and the mischief rule. Have a look at case example 9.2, which is on page 216 of your text. Now it's based on the case of Gent, or Field against Gent, or Gent, which is 1996, 67 SASR 122. So the question for the court was whether the throwing of petrol amounted to the throwing of a missile. In my view, somewhat surprisingly, the majority of the full court of the Supreme Court in South Australia found that it did. Have a look at 9.3, that is case example 9.3. It's on page 220 of your text, and it's based on the case of Gideon against the Commissioner of New South Wales Crime Commission, 2008 HCA 43. You'll see that the facts are that an informer sold Gideon 2.5 kilos of cocaine in circumstances where enforcement officers believed the cocaine would be recovered. It would be sold on to end users in 70,000 to 100,000 packets. Now, the legality of such an operation is under statute in circumstances where the Commissioner may grant authority to conduct a controlled operation, but only if engaging in conduct, unless engaging in conduct that is seriously endanger the health or safety of a party or result in serious loss of property. And in this case, the full High Court decided that any person literally means what it says, in that the operation includes end users. Therefore, the court held that there was no lawful power to conduct its sting operation in this instance. All right, well, thank you very much. You've been very patient. We're going to start next week with a little quiz. So please have your thinking caps on straight away. In the meantime, make sure that you look carefully at the legislation handbook. Have a look at the new pieces of legislation that I've referred you to this evening. Make sure that you've thoroughly read your textbook, and also please read last year's take-home paper. And I do want to make this a little interactive in terms of explaining what you can expect in the take-home paper. We're going to look at what happened last year, and that'll give you a good guide. So please be well prepared for that session next week. As for now, all the best, and we'll see you next week in the live session. Bye now.